My lords, lady, what I propose to do first is briefly to set the scene from Mozambique's perspective. Mozambique issued its claims against Mr Safa, which arise out of a massive and devastating fraud against one of the poorest countries in the world, 7 years ago tomorrow. And after a 3-month trial of those claims, Mr Safa died, and a consequence of that was there was a substantial risk that if his heirs were not joined as parties, then any judgment here would be regarded as a nullity and unenforceable in the courts of his domicile, Lebanon. So, before circulation of the draft judgment, Mozambique applied to join the heirs to allege against them that Mr Safa was liable in respect to the claims against him, and that they had succeeded to that liability as a matter of Lebanese law. And we sought to have joinder and service out determined before judgment, because otherwise the invalidity and enforcement risk would crystallise, which would defeat the purpose. And so after hearing from the parties, including the heirs via Forsters, the judge made a pragmatic case management order, making clear that the judgment that he was to hand down would not determine the claims against Mr Safa, and that he'd reserve all questions as to the consequences of Mr Safa's death, including joinder of the heirs and competing applications to appoint a representative of his estate for consideration at a further hearing or hearings with, if appropriate, further case management. As I'll show you in due course, Mr Safa's estate was not represented at the point of judgment. And that remains the position today. The judge's order following judgment addressed only Mozambique's claims against the other defendants. It didn't address at all the claims against Mr Safa, determine liability, or grant relief and remedy on those claims. Now, on the application for joinder and service out below, various matters were common ground or were not disputed, and that remains the position today. First, that under Lebanese law, on a person's death, the deceased's legal identity ceases to exist. Second, that Lebanese law has no concept of an estate. Instead, the entirety of the deceased's assets and liabilities transfer automatically and directly to the heirs immediately on death in specific shares identified by Lebanese law. Third, in Lebanon, because a dead person has no legal personality, and because there's no concept of an estate with a legal personality, it's the heirs who have got to be sued in place of the deceased. Fourth, there was a substantial risk that unless Mr Safa's heirs were joined, an English judgment might not be enforceable in Lebanon, because the courts of Lebanon, applying Lebanese law, would consider any judgment against Mr Safa or his estate to be a nullity. And fifth, that the appellants were Mr Safa's heirs under Lebanese law, and there was a possibility that one or more of them might disclaim, but there was no evidence that they'd done so at that stage. And things have moved on in that regard, as the court knows, because we now have a decision of the Lebanese court excluding the second and third appellants from their inheritance and distributing the estate to Mrs Safa alone.
Sorry, what was your first point? I haven't gone later to that.
First point of what was common ground? That under Lebanese law on a person's death, the deceased legal identity ceases to exist. And the effect of all of that, as the judge recognised, is that if Mrs Safa isn't joined, then a decision in these proceedings establishing that Mr Safa was liable to Mozambique for very serious wrongdoing could be unenforceable in the courts of his domicile. And even if the English court determines that Mr Safa was liable to Mozambique, his heir, Mrs Safa, could turn around in Lebanon and say that he wasn't. And so, after 7 years of litigation, in England at great expense, Mozambique might have to start all over again and relitigate its entire case on Mr Safa's liability from scratch in Lebanon in order to be able to enforce against his assets, simply as a result of the timing of Mr Safa's death. And in our submission, that was serious injustice to Mozambique and its people. And we submit that the judge was correct to find that that's not an outcome that this court is compelled to adopt when the matter is properly analysed.
Can I just go over to make sure I've understood that? Because it might be argued that if you don't name the widow, or don't make her a party, and the only named party is Mr Safa, by the time you get to Lebanon to enforce, he doesn't exist anymore under
There
Lebanese
is
law, and so they say, well, they throw their hands up and they say that's a nothing.
Precisely. And it wouldn't matter if it's Mr Safa's name or the name of his English estate. Neither of them, there's no concept of an estate.
That's a nothing under
It's a nothing.
Lebanese law. Okay, thank you.
And Malone Friend's case is that the English court's hands are tied, and as we know, the principal argument below was that our claim against Mrs Safa, which they rather tendentiously describe as an administration claim or an estate claim, was one that the court's got no jurisdiction to determine, relying on Dicey Rule 160. And the judge rejected that, and he rejected their case on Gateway and Forum, we say correctly, but since his judgment, there have been two developments which have further cleared away or narrowed the issues. And the first of those is this court's decision in Piffs, upholding Mr Justice Jacobs' decision on whose approach the judge followed. But there's no objection in principle to joining a party to a claim to ensure it's bound by the court's determination, if that's appropriate in the circumstances, and a party joined on that basis is a proper party for the purposes of Gateway 3. And in light of that, Malone Friends accept, first, that there's no jurisdictional bar to a claim on the enforcement basis. It's paragraph 36 of their skeleton. Second, that a claim on the enforcement basis can in principle be served out under Gateway 3, although they say that can't be done here because the claims against Mr Safa have already been tried, and I'll come back to that. And third, they don't take any forum point in relation to the enforcement basis. So in relation to the appeal against the judge's decision to permit joinder and service out on the enforcement basis, the Malone Friends' only remaining ground of challenge is ground 2, Gateway. It's ground 2 or bust. And the second development since the judge's judgment is the issue of the inheritance certificate by the Lebanese court, as a result of which it's undisputed that Mrs Safa is the sole heir. So Malone Friends' arguments on ground 1, that the English court might in these proceedings somehow be treading on the Lebanese court's toes in identifying the heirs, that's fallen away. So having set that scene, I propose to follow the broad structure adopted by Malone Friends' enforcement basis, then substantive basis, if that's convenient to the court. Starting with Gateway 3, and Malone Friends' case that Limb 1 of Gateway 3 isn't satisfied because the claims against Mr Safa have already been tried. It's important in our submission to understand the case management context. Can we go first, please, to the supplementary bundle, tab 4, page 67. This is the judge's order of the 28th of June 2024. So this is after the trial, but before circulation of the draft judgment. And we can take it from the recitals. In the first recital records the death of Mr Safa. The second recital then refers to an application by the 6th and 10th defendants, then Mr Safa's companies, to appoint Mr Azori to represent his estate. And the third recital refers to an application by the Republic, by Mozambique, to join the heirs, that they be joined as defendants, and that they be appointed to represent the estate of Mr Safa. So there's competing representation applications. Then the fourth recital records that Mr Safa's companies were seeking that the parts of the applications concerning the appointment of representatives of his estate be heard prior to the court delivering judgment on the claims, to ensure that the estate of Mr Safa is represented in the Republic proceedings at the point of judgment. Now, the effect of that, judgment on the claims against Mr Safa against his estate, but without the joinder application having first been determined, would have been to crystallise the enforcement risk. And doubtless it would then have been said that there's no gateway for service out post-judgment against his English estate.
Because there's no real issue at that point. Yeah,
precisely. And so the fifth recital then records the Republic's position, requesting that all the applications, including the joinder application, be determined before the handing down of the judgment. And then in the sixth recital, the judge refers to a directions email he sent to the parties in relation to the applications, in which he said that the judgment would record the death of Mr Safa and name him in its title as that was the title at trial, but would indicate that the issue of further steps following his death remained, and if required, he'd be prepared to consider, with the benefit of argument, reissuing the judgment in a suitably revised form or issuing a supplemental judgment. And the seventh recital then refers to correspondence from Forsters, the solicitors for the heirs, that engaged with these directions. And then at the bottom of the page, we've looked at this already. He orders and directs that the following matters will not be determined in or by the judgment. In 1A, all questions as to the consequences of the death of Mr Safa are reserved for subsequent consideration and are to be determined together with the joinder application and the competing representation applications. And at B, in relation to the claims against and made by Mr Safa, so there are claims that Mr Safa himself, he was making Part 20 claims, which are still out there and haven't yet been progressed. The judgment will state only what the outcome of the determination of those claims would have been had Mr Safa not died prior to the judgment. And then at C, the judgment would not determine which persons should be representatives or party to the determination of the Safa claims when those claims are determined on a future occasion. And then at D, that the reserved issues include all questions as to the participation or otherwise of Mr Azori and the Safa family, whether as joined parties or as CPR 19.12 representatives.
Can we go back to B? I hadn't picked up there were claims against Mr Safa as well as claims.
So the claims against Mr Safa, Mozambique's claims, and yeah. Mr Safa was then bringing Part 20 claims against third parties.
And those are still out there?
They're still out there.
Unresolved?
Haven't been resolved.
Well, unresolved in the sense there is no judgment, or there's no order on them, but I thought they had been,
tried.
As per B, the judge has stated what the outcome would have been if he had not died.
It probably doesn't matter for present purposes, but what he did in relation to Mr Safa's claims was he effectively parked the Part 20 claims, including some claims that were made against people who were not currently parties to the proceedings. And so the judge made findings for the purposes of Mozambique's claim in relation to those persons, but said the position might be different on Mr Safa's claim because he had permission to serve out against those parties, and so they were bound to that.
Right, so what has been deferred is not an issue as between Mozambique and Mr Safa?
No, my lord, I apologise if I gave that impression.
No, I was getting it straight in my own mind, thank you.
And then in paragraph 2, Mr Azori is appointed to represent Mr Safa's estate in the Republic's proceedings pro tem and until further order, but for the applications only and the consequentials hearing, and that's to ensure there could be an effective hearing of the applications and the reserved issues. He was only appointed as the estate's representative in the proceedings generally later, after judgment was handed down. It was in October 2024. So the judge is making clear here, and then paragraph 4, the judge orders a hearing for determination to the extent possible and appropriate of the consequential matters arising, including reserved issues and applications, and otherwise for directions for determination of remaining consequential matters. So what we say the judge is doing here is making clear before the circulation of even the draft judgment that he wouldn't be determining the claims against Mr Safa in the judgment, and he was contemplating at least one further hearing with argument and potentially further case management, and a future determination of the claims against Mr Safa, potentially with Mrs Safa's involvement, with the heirs' involvement as joined parties. And this may not matter, but just to complete the picture, if we can turn up the extract from the main judgment, which I believe the court has in loose copy. In the heading on page 2, we see there's Mr Iskandar Safa. His name is the 12th defendant, as the judge had said that he would, but neither Mr Azori nor Mr Safa's estate are mentioned. It doesn't say Mr Safa deceased represented by Mr Azori, and that reflects the limited scope of the order appointing Mr Azori, which was only for the purpose of the applications which we've looked at. And in the absence of a relevant order under CPR 1912(1, appointing a representative, a deceased party's estate isn't bound by any ruling in the proceedings against the deceased. That's CPR 19.12(5). And we've looked at paragraph 34, Milena Friend showed you earlier, where the judge refers back to his 28th of June order.
Sorry, which was, I'm being a bit slow.
Apologies,
I'm behind you. CPR
19.12(5). It's on page 555 of volume 1 of the 2026 White Book. Is CPR 19.12. And 1912(1 is where a person who had an interest in a claim has died and that person has no personal representative, as here. The court may order 1, the claim to proceed in the absence of a person representing the estate of the deceased, or a person to be appointed to represent the estate of the deceased. 2 doesn't matter because that's where a defendant against whom a claim could have been brought has died. And then subparagraph 5, where an order has been made under paragraphs 1 or 2b2, any judgment or order made or given in the claim is binding on the estate of the deceased. So what it's saying is you need an order under 19.1 for our purposes in order for a judgment to be binding. And we don't need to go back to it, but the order following judgment, which Milena Friend took you to, addressed only the claims against the 6th to 10th defendants, Mr Safa's companies, and not the claims against Mr Safa. So there are ongoing substantive proceedings against an anchor defendant in the English courts.
Have we got the judge's email of the 14th of June?
I don't believe it's in the bundle, but we can
We'd
get
be
copies
provided
of
with
that,
that.
of course. What the judge was seeking to do in our submission was to hold the ring and preserve the possibility of joining Mr Safa's heirs before the claims against him were determined. It appears to be Milena Friend's case that was doomed from the outset, that the Rubicons crossed at 4:16 p.m. on the last day of trial.
But to preserve the determination of the claims against him to some future date,
Yes,
but allowing for new submissions, new evidence,
yes,
yes?
yes.
So-
Mr
so
Safa's estate,
the-
as things stand, is not bound by the
So
judgment that
if
we
the
have.
widow is joined, she can fight the whole case again here?
What we said below, and our position hasn't changed, is that if Mrs Safa, the Safa family, are joined, the next stage will be a case management conference, and the judge will doubtless want to give them an opportunity to be heard, including in relation to whether she has any basis to contest Mr Safa's liability. Difficult to see what she might say about that, bearing in mind the emphasis put on the fact that she's had no involvement in any of the relevant
One thing
matters.
she might say is, why should I be bound by a trial in which I didn't participate? And if I'm to be held liable, I need a new trial, and what's more, I need it before a new judge, because this one is plainly made his mind up.
She may say that, and we can't. We accept that she is entitled to have an opportunity to be heard, and that will be debated at the case management stage. And doubtless the judge will have due regard to the principle of finality, but we don't say she's shut out from making whatever submission she wishes at that point.
So she comes in at a stage when it is undecided whether she's bound or not.
Yes. She will be joined. There will then be a process, and then there will be a determination.
So she can say what she likes.
And say what she
The
likes.
judge will decide what the judge decides, and it may or may not come back here.
Yes. I mean, the position at the moment is that there's no judgment binding on Mr Safa's estate. So Mr Safa's estate is in the position of any other litigant post-trial but pre-judgment. And it can apply to put in further evidence or put in further submissions. And the judge, again, doubtless will have due regard to the principle of finality, but that remains the case.
And what will your client's position be at that case management hearing? Will your client's position be that she is bound and not entitled to reopen all the findings, or that she can start again?
Our case will not be that she is bound. Our case may depend upon quite what she wants to say about Mr Safa's liability, and we'll have to have a look at that at the time. But as things stand, she is not bound. And if she rejoined, she would not be bound at this point.
Right. You face with equanimity another 3-month trial, do you?
We don't, and as we say, we may be placing heavy weight on the principle of finality, but it remains to see what she says. I mean, we can't put the cart before the horse. No. She says she had no involvement in any of the wrongdoing. We've got a case where Mr Safa participated himself, who was involved in the wrongdoing, at the trial and gave evidence himself and was represented and made submissions. And it may be that there's very little room for anything else, but we don't know, and we don't say that they're not entitled to put a case before the judge, and we didn't say that below.
Yes, I see.
Now, if the authorities, if I could start with one we have not yet been to, HC Trading, which is in volume B of the authorities bundle. If anyone using hard copies, it's volume B, and it's tab 15. The facts don't really matter, but the case concerned a claim against an anchor defendant, D1, who was a purchaser under contracts for the sale of coal, which are governed by English law and contained an English jurisdiction clause. And the second and third defendants had issued cheques which were intended to secure D1's liability under the sale contracts, and permission to serve out was granted pursuant to Gateway 3, as we see in paragraph 6. And D2, on paragraph 9, page 416, challenged jurisdiction, including on the basis that the anchor claim was unanswerable, D1 had no intention of defending it, and it lacked utility. And then the analysis of Gateway 3 is on page 417. And in paragraph 15, the judge sets out the first limb, the real issue limb, and the two distinct elements. And he says the concept of a real issue denotes a claim which is jurisdictionally founded and substantively viable, i.e. not bound to fail. And there's no issue, no question here that Mozambique's claims against Mr Safa are jurisdictionally founded and not bound to fail. And then the second limb is that it must be reasonable for the court to try it. And in paragraph 16, in the third sentence, he says that, or he explains that it may be reasonable for the court to try a claim against an anchor defendant, even where they had no intention to defend that claim, so no live issue in that sense, so long as some useful purpose or legitimate interest might be served by the prospective grant of summary or final judgment on an uncontested basis against the anchor defendant. Then paragraph 17, he explains that the word try in the first limb of Gateway 3 need not involve a trial in the traditional or formal sense, or even a contested hearing for final relief or summary judgment. It denotes some, this is the penultimate sentence, antepenultimate line, it denotes some form of judicial determination on the claim and grant of relief, as distinct from the administrative process of entering default judgment. And then in paragraph 18, he addresses the question of whether it's reasonable to try the claim. He says that's evaluative, it looks to all the circumstances of the case, it's not an exacting test. And he says that it's in the final paragraph of 18, final sentence of 18, no, antepenultimate sentence of 18, apologies. He says it's only where the court concludes that pursuit of an intrinsically viable anchor claim lacks discernible utility, that it is likely to lead to a conclusion that it's not reasonable to try it. And in paragraph 19, he says that's a intuitive and familiar concept, especially concerning the grant of non-monetary relief and remedy and declarations, and it's a matter of common sense. And we say that here there has been no judicial determination of the claims against Mr Safa and granting relief on them. They remain subject to the judge's adjudicatory jurisdiction, and determining them has obvious utility. And my learned friend referred to two authorities, which I propose to go back to. The first was Erster Group, the Red October case, and that is in tab 8 of the authorities bundle. It's in volume A on the hard copy. And if we could pick it up on page 191, please. No, 190, please. And we see from the first three recitals that the claimant bank had brought proceedings in England against D1, who was the borrower under a loan, and against D2, who was D1's parent and guarantor, seeking the amounts under the loan agreement and a guarantee. And the bank also said that the D1 and D2 and others were party to a conspiracy to put their assets out of its reach by hiving them down. And it brought claims for damages in tort and under Section 423. And the bank had obtained summary judgment on its debt and contractual claims, but it still sought permission in the third recital to serve out on D3 and D5 under the necessary and proper party gateway. And then if we go to paragraph 3 of the head note on page 191, we see what the court actually held. The Court of Appeal held that the bank had participated in the Russian insolvencies of D1 and D2, and so it had submitted to the jurisdiction of the Russian courts in relation to all the issues arising in the insolvencies. That's the ratio. And then it goes on to say, even if there hadn't technically been a submission to the Russian court, the debt and contractual claims were not disputed. They'd been admitted in the liquidation proceedings. And any judgment would have to be taken back to Russia and proved in the insolvency. The guarantee would be regarded of no effect there. The other claims didn't add anything, and there was no utility in the English court trying them. So this was a case about whether there was an issue on the outstanding conspiracy claims that was reasonable to try in the context of an application to serve out on a foreign party. It was not whether there was an issue as between the claimant and the anchor defendant. It's got nothing to do with our case in our submission. Mr Safa's estate hasn't admitted the claims against him, and there's obviously utility in determining them. And my learned friend took you to paragraph 136, which is on, if we can pick it up actually at page 238, please. There's a heading at the bottom of page 238, analysis and conclusions, and 134 explains that the analysis is about forum and not gateway. And over the page we see 135, Lady Justice Gloucester, she identifies the first and foremost factor relied on by the judge as being the conspiracy claims, which are going to be litigated here anyway. And then over the page, in the quotation in the middle, and litigating the same complex issues of fact twice with all the attendant waste of costs and risk of inconsistent findings in two jurisdictions. So that's the forum point that was being taken. And then in 136, what's being addressed in 136 is that it was unrealistic to suppose that actually there was ever going to be a trial in England on the merits and based on evidence of the conspiracy claims. So it's a forum point, it's not a gateway point. The next authority...
I think that we were taken to paragraph 78.
Yes, 78 was dealing with the first point that I showed you from the head note, that they'd already got judgment on the claims on the contract and the guarantee, and that there was the other claims added nothing, and therefore there was no utility. That's all about reasonable, that it's reasonable to try a claim in the context of service out.
But I think the point being made about utility, as I understand it, is as between the claimant and the anchor defendant.
Yes, precisely.
Because they already had judgment for X.
Yes.
And the conspiracy claim would not have been worth more than X.
Yes.
So what's the point?
Yes, precisely.
That seems to have been in addition to the point about submitting to the Russian jurisdiction.
Yes.
So what's your submission about how that case is different from this case?
Well, there's plainly utility in determining and adjudicating the claims against Mr Safa's estate, getting a judgment against his English estate. That's going to be necessary if we ever want to enforce against any assets here. My friend said there may be some. It'll be necessary if we want to enforce against his assets anywhere else that has a system that requires a judgment against the deceased person's estate. It'll also be necessary in any event if we're to have a hope of enforcing against his assets in Lebanon. We're still going to need a determination, an adjudication of the claims against him, rather than being left in limbo after a 3-month trial. The next case my friend went to was the hotel portfolio case that the court helpfully drew to our attention this morning. And the relevant issue in hotel portfolio was a post-judgment application by the claimant to join a third party, Grender, for the purpose of binding it to the findings in the judgment. It wasn't dealing with the first limb of Gateway 3, and the context is important and is very different. We can look at paragraph 28 on page 13. The issue of whether Grender should be joined to the trial, which culminated in the judgment, had been specifically considered at a joint CMC PTR prior to the trial. So the application and the decision was taken. We see this about just over halfway down. In those circumstances, the decision was taken not to join either Mr Barton or Grender to the trial. So it's a rather opportunistic application in that sense. But here, of course, the issue of potential joinder only arose post-trial. It only arose post-trial because of facts and changed circumstances with the death of Mr Safa. And in paragraph 25, it's on page 12, Mr Justice Foxton, as he then was, explained the purpose of joinder in various post-judgment cases he had referred to was essentially forward-looking, to allow the new party to enforce relief if it had succeeded to the rights of the former claimant, or to allow a new party to be bound by and have the opportunity to be heard in relation to matters which had yet to be determined, but which would arise in post-judgment proceedings. I mean, in our respectful submission, he wasn't sort of purporting to set out exhaustively the categories of case in which post-judgment joinder might be appropriate, but we submit that the two examples that he gave are helpful. As to the former, we're effectively in the reverse situation, where the point of joining Mrs Safa is to allow us to enforce relief to be granted against the person who has succeeded to the liability of the former defendant as a matter of the law of his domicile. And as to the second, as the latter point Mr Justice Foxton identified, the purpose of joining Mrs Safa is forward-looking. It's to allow her to be bound by and have an opportunity to be heard in relation to matters which have expressly not been determined, namely the liability of Mr Safa to Mozambique. And my learned friends haven't identified any authority for the proposition that Gateway 3 is simply not available following a trial, even where there's not yet been a final judgment or order against the anchor defendant. In our submission, it can't properly be said that claims that haven't been determined and are still to be the subject of a final judicial decision aren't issues for the purposes of Gateway 3, or here that it wouldn't be reasonable for the court finally to determine and grant relief on those claims for the reasons that I've explained. And when friends say, well, it's now just a question of entry of judgment or perfection of the order. But there's no basis for that either. Mr Safa's Part 1912 representative, Mr Azori, hasn't admitted the claims. He's not admitted that the estate is bound by the findings in the judgment, and rightly. And he's not said that the judgment can now simply be entered against the estate in its current form or at all. The claims and issues remain live and at large. The judge's order contemplates that he'll want to hear from the parties before finally determining the claims. We don't know what Mr Azori will say on liability, remedy, costs or appeal. My learned friends can't in our submission, and the court should not in our submission, proceed on an assumption that he'll say nothing about anything. This is not a case where defendants have been shy of taking points. As I said, like any other litigant, he's not precluded from applying to put in further submissions or evidence. He might seek to say that there's new evidence that's material and couldn't have been adduced at trial, or that matters have moved on since 2023 in relevant respects, including in the period from Mr Safa's death to the point of handing down of judgment, when his estate wasn't represented at all. The judgment states...
How realistic is this? Because according to Mr Howe, Mr Safa and the Privinvest companies are in precisely the same position. And there is judgment against them, which presumably would stand, even if Mrs Safa comes along and says, I've got a whole load of new evidence, which puts things in a very different light.
Well, the judgment would stand against them, yes, but she's nevertheless entitled to say that. So there's not a judgment against me, and she may say things have occurred since the judgment was handed down and the order was made against those companies. In relation to appeal, for example, so learned friend explained that Mr Safa's companies had obtained permission to appeal. It was sufficiently arguable to pass that threshold, but the appeal was struck out on procedural grounds for failing to comply with conditions. But what he didn't explain is that Mr Safa's companies then sought to have the appeal reinstated. They wanted relief from sanctions, including on the basis that it raised issues that might well be raised by Mr Safa's estate on appeal in any event in due course. So it's a real possibility that the overarching point there in our submission is that until there's been a final and binding determination of the claims against Mr Safa's estate and grant of relief on them, there remain live and undetermined issues between Mozambique and the anchor defendant. The gateway is open. There may be questions about proper party or discretion, but those aren't issues on this appeal.
The gateway is swinging closed, but it's not locked yet, is what you're saying.
Lordship put that beautifully. But friends, only other point on the enforcement basis is the pleading point. This was not a point taken below, and it could have been. They had our pleading. It was not even a point taken in their submissions on Mr Justice Jacobs' decision in PIFs. We don't need to go back to it, but my Lord Justice Males is entirely right. They took 2 points. They said he was wrong, but this court has said that he wasn't. And they said it was distinguishable because PIFs was pre-trial, and we've been looking at that point separately. Our pleading is, if we can just go back to that, in the core bundle, it's tab 9, page 108. paragraph 10 says, in the premises, Mrs Safa is the heir of Mr Safa under Lebanese law, and that's not disputed. Then 10.2, we understand that's not disputed either, in the sense that she has succeeded to the assets and liabilities of Mr Safa and is liable in respect, in Lebanese law, in respect of, and to the extent that liabilities have passed, there might be an issue about what their hereditary liabilities are. But for present purposes, 10.3, Mr Safa is liable to the Republic for the reasons and in the amounts pleaded in the particulars of claim. That is an allegation as between Mozambique and Mrs Safa that Mr Safa is liable to Mozambique. That is an enforcement basis claim. And then paragraph 10.4 goes on to allege that in the further premises, Mrs Safa has succeeded to Mr Safa's liabilities to the Republic and is liable to the Republic in the same manner, to the same extent, subject to pleaded limits. And that's the substantive basis claim. So in our submission, we have pleaded it sufficiently. The court's hands aren't tied to grant a declaration in those terms. I can deal now with the substantive basis.
So what's your, just if you can put it in a nutshell, what's, going back to the rule, it requires there is between the claimant and defendant a real issue which is reasonable for the court to try. What do you say is the issue that it's reasonable for the court to try?
The question of liability, remedy, relief on the claims against Mr Safa, which have not been determined. There's no judgment against that's binding on his estate, and the judge deliberately retained his adjudicatory jurisdiction over and is seized with those issues. The substantive basis. If I could start, please, with the appellant's expert evidence.
Just before you
Yes.
go there, while we've got the pleading open, are you claiming a money judgment?
No.
No. A declaratory judgment.
Declaratory judgment in those terms, which would put us in the same position as if we'd had a judgment against Mr Safa the day before he died. We'd have a judgment that we could then take to Lebanon, and there'd be argument about enforcement or what have you.
Is it then doing anything more than, on this substantive basis, is it then doing anything more than effectively saying, we've got this judgment against Mr Safa, and Mrs Safa's a party to those proceedings, assuming you're right on the enforcement bit, so she can't then say, you've got to argue that all over again. So assume all of that.
Yes.
Is the next bit really doing anything more than saying, and it is declared that Mrs Safa has such liabilities as she has under the law of Lebanon?
Well, no. There would be there's a sort of middle stage, if you like. So stage one is enforcement basis, that she is bound by the finding as regards Mr Safa's liability to Mozambique. She then says so far there are 2 points of Lebanese law, which means that liability doesn't pass to me. And so far those 2 points that have been articulated are these: that a liability in tort relating to wrongdoing prior to death, but that has not been quantified prior to death, doesn't pass. That's the point, and it'll have to be determined. The second point is that tort liability arising out of criminal conduct doesn't pass as a matter of Lebanese law. So we would seek to have those issues. It may be that others are raised in due course. We don't yet have a responsive pleading, but we would deal with those issues. So what we would have is a judgment saying she is responsible for Mr Safa's for the consequences of Mr Safa's wrongdoing, but not quantifying that by reference to what other assets she's received and what have you in Lebanon.
Or what other liabilities there may be.
Yes. Yeah, we wouldn't be touching those.
And who sorts out the points about liability and tort unquantified prior to death doesn't pass and the issues that she's raised?
The English court. The English court.
The English court sorts that out with,
Yes.
with expert advice on what Lebanese.
There's already expert evidence on those points. And as the judge said, they don't appear to be overly complicated. If I can start with, as I say, with the appellant's expert evidence, which is in the supplementary bundle, tab 6. And this is important in light of some of the submissions that the court heard this morning. This is a report of Professor Slim.
Sorry, I've lost the.
I apologise. It's in the supplementary bundle, tab 6. And if we could pick it up, please, on page 86. There's a heading, the inexistence of a concept similar to the concept of an estate under Lebanese law. And Professor Slim then explains in paragraph 34 that the concept of an estate in the meaning of the aggregate of all the assets owned by a deceased person, less all his/her liabilities, does not exist in Lebanon. And then he continues, in addition, there's no mandatory procedure under Lebanese law similar to the estate administration, so nothing even similar. And then, and this is the point that Lord Justice Miles picked up on this morning, on page 89, page 51, paragraph 51, at the top of the page, Professor Slim explains that a literal reading of this article, it's Article 13 of the relevant law, and of the Sharia maxim, no inheritance until after the settlement of debts, and I've very much that several times, could suggest that they prescribe the transfer of the assets left by deceased at his/her death before the payment of his debts. 52. However, such a reading understanding is not correct. And then at the bottom of the paragraph, the maxim, no inheritance until after the settlement of debts, is not interpreted as prescribing the transfer of the assets left by a deceased person before the payment of his/her debts. And then over the page, on page 90, in paragraph 64, Professor Slim explains that the Lebanese courts consider that the rights, assets and debts left by the deceased vest immediately upon death in the heirs before the settlement of debts. And in paragraph 67, on page 91.
Sorry, which paragraph is that?
So that was paragraph 64 on page 90.
Yeah.
I'm sorry, please do tell me if I'm taking this too quickly. In paragraph 67 on page 91, in the final two lines, Professor Slim explains that the deceased's creditors are exposed to the risk that the deceased assets may be mixed up with the heir's proper assets. So pausing there, there's no requirement to pay liabilities before the assets vest in the heirs, and inherited assets don't have to be ring-fenced and can be mixed up with the heir's own. And then in paragraph 70, he refers to a judgment of the Lebanese Court of Cassation, apologies for the French, where it states in the first sentence that the patrimony of the deceased is transferred to the heir by virtue of the death so that it merges with the heir's patrimony. And the patrimony is the deceased's assets, rights, obligations and debts. So they become simply the heir's assets, rights, obligations and debts. Liability to discharge the debts is part of the inheritance, it's part of the succession, it's not part of an antecedent step of administering assets and paying debts before the surplus is distributed.
So if there is a claim against the heir by a creditor of the deceased, there would need to be some kind of inquiry to ascertain the value of the assets which
Of the assets received.
received.
Yes, I mean, ultimately it's a question of fact. It's just how much did you receive and have you paid any other creditors? But we're not asking the court to get into that.
So that would be a thing for the Lebanese court to do.
Yeah, as I'll show the court later, in fact, there's no evidence that there's any issue about any of that. And the inheritance certificate itself, on its face, records a inheritance tax license has been granted, and I'll show you some of the evidence where what they suggest is that in fact the inventory process takes place prior to the application for the certificate of inheritance. But in some respects it doesn't matter because we're not asking the court.
Is that binding on creditors?
I don't know.
Because the creditor might well say, well, you've come up with a low value of assets for that purpose, and in fact they're worth a load more.
I entirely see the point. I don't have the answer, my lord. I don't think we have evidence on
Anyway, you say that's a matter for the Lebanese court.
Yes, yes. And then the next point is on page 100. In paragraph 137, Professor Slim explains in the first sentence that though the assets and debts of the deceased immediately vest upon the death in his or her heirs, these heirs are only liable within the limits of the assets they receive. That's the point we've just been discussing. And in the final sentence, thus the debts are supposed to be apportioned among the heirs within the limits of the amounts received by each of them. So there's an apportionment and division of the deceased estate into individual shares among the heirs immediately on death. It doesn't in fact matter in our case because there's only one heir, but the point is important when we look at some of the authorities in Villegas, which I'll take the court to later. And finally on page 101, paragraph 142, Professor Slim refers to a judgment of the Lebanese Court of Appeal which makes the point that in Lebanon an heir is not prohibited from disposing of inherited assets prior to the settlement of debts, but is personally liable for the deceased debts within the limits of what he/she received from the inheritance. So the heir can dispose of assets which have merged with and can be mixed up with their own before the debts are paid. But if they do, they'll be personally liable up to the amount of the inherited assets. But that's important because it means, as I said before, that there's no ring fencing or hypothecation of inherited assets until debts are paid. And the notion that a personal representative could commingle inherited assets with their own assets and spend them as they want before discharging debts is antithetical to administration as English law conceives of it. And that's the appellant's own evidence. Turning then to the authorities. The learned friend went first to Dicey. I'd just like to show the court one additional point. That's in Authorities Bundle B in the hard copy, tab 20. And on page 629, it's quite a thick extract. And so Rule 160 set out there is a foreign personal representative is not, as such, under any liability in England and cannot, as foreign personal representative, be sued in England. And of course, see the footnote 146, and the most recent English authority for that proposition is Degazon, which I'll come on to. And then the commentary at 2742 below says that a foreign personal representative cannot be made liable in England for property held or acts done by him or her in his or her character of foreign administrator. This is so even if he or she acknowledges service and submits to the jurisdiction, for he or she has no power to submit the assets he or she holds to the judgment of the English court. And I'll develop this submission, but we respectfully submit that Rule 160 has got no application here. We don't seek to sue Mrs Safa as a foreign personal representative as such, and we don't seek to make her liable for property held by her in any character of foreign administrator. We're suing her as the sole successor to Mr Safa's liabilities, which are passed to her personally by operation of Lebanese law and merged with her own. And we aren't seeking to submit assets held by a foreign personal representative as such to the English court. Mrs Safa has power to deal with the assets that she's inherited. They are her assets, they've merged with her own, she owns them. We can go next to Degazon, please. Which is in the first bundle of authorities, tab 3. Degazon was an action brought by the claimant in England to recover fees for legal services against an executor under a foreign grant of probate, that's Barclays Bank, of a former client who died in Dominica. And Barclays said, we can see this at the end of the head note, that an action against it as executor wasn't maintainable since a personal representative could be sued within the jurisdiction, could only be sued within the jurisdiction of the court in which it was granted probate or letters of administration. And on page 36 is the highlighted passage that my friend took you to, whereby the Court of Appeal had drawn counsel's attention to what appeared to be a jurisdictional bar, or at any rate the settled practice under rules of private international law, that a personal representative who had obtained probate or letters of administration in a foreign country could not be sued in that capacity in our courts.
So was the bank here?
No, the bank was had letters of probate in Dominica, I believe.
So was
Yes.
this a service out case or a...
No, it was...
And it may not
It
know.
looks like it's a forum case.
So we're after a stay.
Yes. But your Lordship sees 1, 2, 3, 4, 5. 7 lines down, the bank was granted probate by the High Court of Dominica.
But the bank itself is a...
Top of page 34, it says that the bank had a branch in Dominica. Its head office was in London, but had played no active part in the history. So whether the bank was served with proceedings here seems quite possible.
Yeah,
It does, yeah. I'm grateful, my Lord.
thank you.
Page 37, at the top of the page, they sets out Rule 133 in Dicey, which is now Rule 160. Then on page 138, there is a heading, the rule upon which the bank relies. And in the second paragraph beneath that starts to demonstrate. It refers in the first sentence to a decision of the Court of Appeal in Alberta, that's Nova and Grove, which my friend took you to. And about a third of the way down this rather long paragraph, we see that we're told that in Nova and Grove, one of the defendants sued in tort was the executor of a person alleged to have been concerned with the design and manufacture of the valve to whom probate had been granted in Texas. And the plaintiffs had obtained leave to serve out on that Texan defendant. So Nova and Grove was another claim brought expressly against an executor under a foreign grant of probate and in their capacity as such. And because he was an executor under a foreign grant of probate in Texas, the Albertan court said he had to be sued in the courts of the territory in which he had been appointed. And at the end of the paragraph, there's a passage from the judgment of Justice of Appeal Stevenson, which the Court of Appeal said was particularly helpful, where it sought to obtain a money judgment against a foreign personal representative. All the authorities to which we referred or had resort deny the jurisdiction of any forum other than that which appointed the personal representative. It would appear that the primary reason for the rule is the one cited by Mr Justice Laycraft, namely that all questions relating to the administration of the estate ought to be determined by the forum which authorised the personal representative to act. The settlement of liabilities, as distinct from the distribution of assets, is a fundamental part of the administration of an estate. Moreover, and probably as a consequence of this rule, probate or administrative grants are local and territorial and are not generally recognised as having any extraterritorial effect. So, the underlying rationale expressed here is the territoriality of personal representation deriving from a grant of authority from a local court. One of the friends in their skeleton refer to Nova and Grove and a passage which we don't need to turn up, but which says that the administration of the estate will be impossible if it's subject to the direction of two different authorities. The English court won't trespass on a task that's already being undertaken by the foreign court. That's the point. And the rule as expressed here in Degazon clearly contemplates a two-stage process with a distinct administration phase involving the settlement of liabilities before a subsequent distribution of assets. And Lord Justice Kerr at the bottom of the page then refers to the principal English authorities in the final paragraph, the most recent of which was 1861, and then in the last line and over the page to a more recent decision of the Irish Court of Appeal in 1918, Sweeney and Murphy, which he said was of greater assistance because it's concerned with the principles underlying the rule. And he explains that in that case, the plaintiff had sued in Ireland the administrator of an English estate under an English grant for maladministration on the ground that she was domiciled and resident in Ireland. And at the bottom of the paragraph, there's a quote from Lord Justice O'Connor, and he says, "The defendant has, in England, the capacity of a personal representative of this deceased gentleman. That's because she had an English grant, and can be sued in England as such, in her capacity as administrator under an English grant. But the moment she crosses the channel, she becomes a private individual. Accordingly, when administration proceedings are instituted against her in this country, these are for maladministration, this country being Ireland, they necessarily fail because the defendant is outside the jurisdiction of the court which made the grant." Now, one can see that the rule operates clearly where there's a court-appointed foreign personal representative under an English-style system, but we aren't aware of any case where it's been applied in any other situation, and learned friends haven't cited any. They haven't identified any case in which the rule has been applied in the 40 years since Degazon, and no case on remotely similar facts. And for our purposes, the point is that on any view, their case would involve a novel application of the rule. We're looking at serious issues to be tried here. There's nothing to suggest that it's intended to bar a claim against a person who has not been appointed by a foreign court to conduct a distinct administration phase and who has succeeded to assets and liabilities in their personal capacity of a person who died in the course of proceedings before the English court. Learned friend then took you very briefly to Achillopoulos, which I can deal with even more briefly. I don't think we need to turn it up, in fact. It was a case, as my learned friend showed you, about a subsidiary administration in this country which was taken out by the attorney of foreign heirs under a will, pursuant to letters of administration in respect of English assets belonging to the foreign testator. And the issue was who the English administrator should pay the balance of the funds to, who could give a good receipt for the funds. And in that context, the court said it's permissible to pay it to the heirs under the will, who, on the expert evidence of Greek law, were under, as Lord Justice Miles pointed out, the same duties as an executor or administrator over here, including seeing that the debts are paid before distributing the ultimate surplus. That was the passage at top of page 15. And that's not this case. And that was in circumstances where the executor under Greek law, the actual named executor, whose position was one of supervision, was a party to the proceedings and assented. So Achillopoulos didn't concern a claim against a foreign heir. It had nothing to do with Rule 160, and it's got nothing to do with jurisdiction in our submission. And then there's Viegas, and I apologise in advance. I do need to take the court through this in some detail. It's in hard copy, volume B, behind tab 16. And in our submission, Viegas, when properly analysed, is not only consistent with, but supports our case, and certainly nothing in it detracts from our case, and certainly isn't a knockout blow. Curiously, it doesn't even mention Rule 160, or Degazon, or Nova and Grove, or the principle that Malone Friends seek to rely on. If we can start at page 448, please. It's clear from the heading at the bottom of the page that Viegas was relevantly a case about standing. Claims appeal grounds 2 and 3, standing of heirs. The issue was whether claims could be brought in England by individuals who claimed on behalf of the estates of deceased persons on the basis that they were entitled to do so under Brazilian law, but who hadn't obtained grants of representation here. That was the issue. We see the judge's conclusion, it was Dame Claire Mulder, at 73 on page 449, in the quoted passage. Insofar as the claim is brought before the distribution of assets to the beneficiaries, this stage is the administration of the estate, and an English grant is required in order for the heirs to bring the claim and collect the assets on behalf of those entitled. So I apologise. Page 449, paragraph 73. And in the second sentence, there's a quote, insofar. This is a quote from the judge. Perhaps I could just ask the court to read that to itself. So there's nothing particularly surprising about that, and unsurprisingly, this court agreed with that conclusion. Now, Malone and friends say, well, we're in the same position as the claimants in Viegas, but Viegas is an entirely different scenario. If we can pick it up on page 454, Lord Justice Newey addressed the expert evidence of Brazilian law. In paragraph 91, in the first two sentences, sets out that a person's assets and rights are immediately and automatically transferred to his heirs on death, but as a unitary whole, with the rights of heirs governed by rules of joint ownership. And importantly then, in the final sentence, until distribution, the moment at which each heir obtains individualised title, all heirs own everything and are subject to the same rights and obligations as those of joint property owners. And then in paragraph 97, on page 455, Lord Justice Newey sets out the judge's conclusion on the nature of the rights of the heirs as a matter of Brazilian law prior to the distribution of the assets and the transfer being recorded in the Formal de Partilha, which is a Brazilian register. And 243 of the quotation, it seems to me that on the evidence of Brazilian law, that notwithstanding the personal interest of an heir in the pool of assets, just dropping down, the heir is defending the interests of the whole because he doesn't have an individualised interest. And this, coupled with the fact that the proceeds do not automatically form part of the estate but are subject to the distribution process, lead me to conclude that the heir cannot be said to have an absolute entitlement to the property. And then in 244, Professor Schenk accepted in cross-examination, of course we're not at that stage yet, that the estate exists from the death of the deceased until the point at which the assets are distributed. There's no estate in Lebanon. On the Brazilian law evidence, prior to the transfer of the litigation rights of the deceased person to the relevant heir, as recorded in the Brazilian register, the heir brings the claim on behalf of the estate as a whole, and accordingly, in my view, this should be characterised as part of the administration of the estate. And that's the context for Lord Justice Newey's analysis, which is in the highlighted passage, some of which Malone Friend took you to earlier on page 463. And if we could go to that, please.
463.
463. Starting at paragraph 120, he says, in broad terms, under English law, matters relating to the collection of a deceased person's assets and the payment of debts are considered to relate to the administration of estates, and the distribution of assets after that is considered to relate to succession. And in the final sentence, he refers to the statement of Mr Justice Henderson in the High Commissioner for Pakistan case, which my learned friend took you to, that it's only when one gets to the question of succession and who's beneficially entitled to share in the estate that one looks to the law of the domicile of the deceased. We are suing Mrs Safa as the only person beneficially entitled to Mr Safa's assets and the only person responsible for his liabilities. Then in paragraph 121, and my learned friend didn't take you to this, Lord Justice Newey referred to a similar distinction in the judgment of Mr Justice Slade in, they keep coming, Haji Uano, where noting in the second sentence there that a widow and children only acquired a sufficient interest in, it was a Greek judgment obtained by the deceased in which he'd applied to register here. They only acquired a sufficient interest to do that when they accepted their inheritance rights, as Mrs Safa has done here, as confirmed by the inheritance certificate. And then in the next sentence, Mr Justice Slade observed the courts in England will permit a party who has an absolute entitlement to it, and that's Lord Justice Newey's emphasis, to a deceased's property in accordance with the law of their domicile, to enforce in this country that party's claim in a personal and not representative capacity. And Mrs Safa has an absolute entitlement in accordance with Lebanese law. If she could bring a claim here in her personal capacity, there's no reason why she can't be sued on a claim here in her personal capacity. And then in page 122, Lord Justice Newey refers to the Vankelin case. I apologise to any French speakers, which Mr Justice Slade had said earlier in the Lord Justice Newey had referred earlier in the judgment. It's paragraph 110 on page 460. We don't need to turn it up, but he referred to Mr Justice Slade's comment that Vankelin was an apposite example of how the English courts will permit a party who's got an absolute entitlement to deceased property to in accordance with the laws of their domicile, to enforce in this country that party's claim in a personal and not a representative capacity. And about two-thirds of the way down, 122, Lord Justice Newey says that the explanation for the court's decision is that the court assumed that under French law the plaintiff had become entitled to the claim she was bringing on an out-and-out basis, and so succeeded to it. Under Lebanese law, as I've shown you, Mr Safa's assets and liabilities have transferred to Mrs Safa on an out-and-out basis. They've merged with her own, and so she is to be treated as having succeeded to them in our submission. And then in paragraph 123, Lord Justice Newey refers again to the distinction between collecting a deceased person's assets and paying debts, and the distribution of assets after that, and says that the question of whether the heirs are entitled to sue fell to be treated as one relating to administration rather than succession. And then he sets out the reasons for that. And in the second sentence of 123, he says that under Brazilian law, on the judge's findings, an heir can bring proceedings relating to the estate. Although an heir can bring proceedings relating to the estate, an heir does not acquire an individualised interest until sharing. And then up to that point, any claim that an heir makes is in defence of the common patrimony, the common heritage, and the whole inheritance. And then in the highlighted passage, it's only when sharing was carried out that an heir obtained an individualised absolute interest in an asset which had belonged to the deceased person. And it was only then on the sharing that in the eyes of English law there was succession rather than administration. And we say Mrs Safa has obtained exactly that interest. She is the only person entitled to Mr Safa's assets and the only person responsible for his liabilities.
And that happened when the other two renounced their inheritance? Or
yes, so it's a very good question. There's prior to that part of the inheritance certificate and the two renouncing their inheritance not being confirmed by the Lebanese court, the estate had been, if I can use that word, had been divided into three portions. Portion of assets and debts, 1 to Mrs Safa, portion 2 to Alejandro, portion 3 to Akram. Still individualised shares. There's no common point. They're each entitled to it's not 1/3, and I forget what the precise proportions are, but for present purposes assume they're each entitled to 1/3 of the assets and 1/3 of the liabilities. They're not jointly and severally liable for the whole. So there was an individualised sharing at that point. But now we can forget about the complication, because on the issue of the inheritance certificate, as my Lord says, there is only one heir who's entitled to everything and responsible for everything. So here, Mozambique's claim isn't brought by alleged heirs seeking to collect in English assets on behalf of the estate as a whole before a subsequent sharing process. It's a claim against Mrs Safa in her personal capacity in circumstances where she is the only person beneficially entitled to Mr Safa's assets and responsible for his liabilities under Lebanese law, and she is to be viewed as having succeeded to them. So, pulling the Lebanese law evidence and the authorities together, we've got four submissions. And the first is this, that Mrs Safa just isn't to be characterised as a foreign personal representative so as to engage Rule 160. This isn't a case where a foreign personal representative has been appointed by a grant from a foreign court, like in Nova and Grove and Degazan. There's just no such process in Lebanon. There's a totally different legal architecture. And the expert evidence is that in Lebanon, assets and liabilities pass immediately in divided and individual shares to the beneficiaries and merge with the heir's own. There's no prior process of settling liabilities from the corpus of an estate before that division. The heir is not obliged to pay the deceased debts before taking and using inherited assets. There's no obligation to ring fence or keep inherited assets separate from personal assets, and creditors are at risk. The heir can commingle inherited and personal assets, can spend or dispose of them in any manner that they choose before discharging inherited debts. And so distribution in our submission, which in English law brings an end to administration, occurs immediately on death. None of that is consistent with administration in an English sense. And my learned friends say, well, no, a deceased assets can only be passed by succession after any liabilities have been settled, and so the ascertainment and payment of liabilities will always be part of the administration of a foreign estate. But in our respectful submission, that's an overly rigid and formalistic approach, which ignores the evidence that there is no process for settling the deceased debts prior to distribution. That there simply is not that process.
And therefore nothing in Lebanon that we would recognise as administration.
The assets and liabilities vest immediately, and they merge with the heir's own assets and liabilities. And I'm repeating myself, the heirs aren't obliged to keep them separate and can commingle. And one could equally look at it from the other direction and say, well, there's only one heir in whom all of Mr Safa's assets and liabilities are vested and merged. She's free to treat the inherited assets as her own, spend them in any manner that she chooses. There's no subsequent sharing or distribution stage. So distribution has happened, and that's only consistent with succession. Our second submission, and this picks up on my Lord Justice Males's question to me earlier, is that even if Mrs Safa is not to be treated as having succeeded immediately on death, she is to be viewed, for the purposes of Rule 160, as having done so and any administration as having concluded on the issue of the inheritance certificate. And this appeared to be my learned friend's case below, if I can show you that. If we start with the witness statement of Mr Walton, we're in a supplementary bundle. Tab
Finished
5,
with
please.
Viegas.
Sorry?
Have we finished with Viegas?
Oh, we have, I'm sorry.
That's
Lord.
right.
And any other authorities for the time
that's
being?
fine.
Sorry, what was the reference?
We're in the supplementary bundle, tab 5, page 73, please. And at the bottom of the page, in paragraph 10, Mr Walton explains that he's been informed by the appellants, the Safa family, that the administration and management of Mr Safa's estate spans multiple jurisdictions, it's highly complex, and it's required the instruction of separate legal teams. I'm told they have been working together for the last 8 months. This is September 2024, just to fix the chronology, with a view to progressing the administration and management of the deceased estate. While significant progress has been made, several administrative and legal issues remain outstanding. Once these issues have been resolved, the respondent will be in a position to apply for the necessary inheritance certificate. And then, if we take what my learned friends had to say about that in tab 9 of this same bundle. This is the appellant's skeleton below. If we go to page 158, please. In paragraph 13, it argues that Mozambique was asking the English court to take jurisdiction over the Safa family, notwithstanding the Little Roman II, no certificate of inheritance estate determination order has been applied for in Lebanon. And then in 14.1, they say in the second sentence about two-thirds of the way down. Because Lebanon is a civil law jurisdiction which doesn't have the concept of intermediate administration, the administration of Mr Safa's affairs is dealt with in Lebanon via the drawing up of an inventory of his estate and the making by the Lebanese court of a certificate of inheritance estate determination order. The applicant asked the English court to circumvent that process. And of course we've got that. And then if we go on to page 172, in paragraph 56, they say that the expert evidence is that there's an available juridical process in Lebanon for ascertaining the heirs of a deceased person and drawing up a valuation of the assets and liabilities of the deceased, which leads to an estate determination order, which is then the basis for an application to substitute a deceased defendant with his legally identified heirs. And in paragraph 57, by the application, Mozambique, in effect, asked the English court to arrogate to itself jurisdiction to carry out the entire administration of the estate and make an estate determination order. So their evidence and their case appears to be that the issuing of the certificate of inheritance, the estate determination order, was the culmination of the administration process. And the evidence is that there's only one formal step in Lebanon, the inheritance certificate, and that provides a public record on which third parties can rely, and it now confirms there's a single heir in whom all assets and liabilities are vested, and to whom, it says, the entire estate has been distributed. That's the word used in the certificate. And there's no evidence of any other process of administration in the Lebanese courts that remains to be completed. And so our second fallback submission is that my learned friends were right first time, and the inheritance certificate is the point at which any administration concluded. And our third submission is that in any event, as the judge held, Mozambique isn't seeking to impose liability on Mrs Safa in any capacity as a foreign personal representative. So even if her position in Lebanon is to be treated as comprising some sort of hybrid, comprising ongoing elements of administration, the character in which we seek to sue her is as the person who succeeded to his liability in respect of our claim against him. She's the only appropriate and possible defendant under Lebanese law in her capacity as successor. And if we just stand back, the English court's not being asked to determine any issues of foreign administration in relation to a non-existent estate. Our claim's got three limbs, essentially. The first is whether Mr Safa committed wrongdoing for which he came under a liability to compensate Mozambique. Now, our claim on the enforcement basis would stop there, and we'll learn if friends accept that doesn't involve any question of administration. The second limb, then, is who has inherited Mr Safa's liabilities generally under Lebanese law. And that's clearly an issue of succession, and it's common ground that it's Mrs Safa. And the third limb is whether Mr Safa's liability to Mozambique has passed to her under Lebanese law. And in our submission, that is also clearly an issue of succession. So our fourth, and this our overarching submission, is that for all those reasons, essentially, there's at the very least a serious issue to be tried that the claim isn't barred by Rule 160. Four short subpoints. One, Miller Friends' case on Rule 160 would involve a novel application of a rule developed in a very different context, where you have a foreign personal representative appointed pursuant to a grant by a foreign court under an English-style system. As I said, they've identified no recent case in which the rule has been applied at all, none on remotely similar facts, none involve a defendant who has not been appointed pursuant to a grant by a foreign court, none concern a defendant who is absolutely entitled to the deceased's assets and liabilities, and none involve a deceased dying during properly constituted proceedings here. One can see that the comity considerations might be different in that context. We don't need to resolve any of those issues now. We say it goes to whether there's a serious issue to be tried. Second, whether, and if so how, the rule applies in other contexts will be informed by the local law. And on the basis of Miller Friends' own Lebanese law evidence, we submit that at the very least, for present purposes, it's not clear that the claim is unarguably on the wrong side of the line, if I can put it that way with lots of negatives. To the extent that there are disputes about the expert evidence, those are matters for trial. Third point.
So that's something on which there could be further elucidation through cross-examination,
yes.
for example.
Do we accept that? Third point is a related point. We say, look, the court should be cautious, respectfully, in determining a point of law that's not without complication and of some importance in circumstances where it can't be confident that it's got all the relevant material with which to make a decision that might not unfairly prejudice either party. No defence has been served, no disclosure has been given, the evidential material available to the court is limited and untested, and it is an issue that can properly be left to trial. And fourth, we say that Mr Justice Jacobs granted permission to serve a claim out of the jurisdiction on the foreign heirs in PIFs that included a claim that they were jointly and severally liable to PIFs. We don't need to go back to it, but my learned friend took you to the passages where Mr Justice Jacobs said the question of whether the court would at trial be in a position to determine the heirs' joint and several liability was by no means straightforward. But he didn't have to come to a final view, and he didn't come to a final view on that at the present stage. And then he said it would be, made very clear, it would be open to PIFs in due course to say at trial that the court should be imposing joint and several liability on the heirs, although the heirs would no doubt argue that that was inappropriate. And then this is in paragraph 59 of his judgment. Again, we don't need to turn it up, but he dismissed the heirs' application to set aside service out in its entirety. And we respectfully submit that the court should adopt the same approach and resist Millennium Friend's invitation to decide summarily and without hearing evidence that Mozambique's claim is irretrievably barred by Rule 160.
I've been wondering whether the distinction between the enforcement basis and the substantive basis may be too stark, because the substantive basis may be divisible according to the relief which is actually sought. It looks as if in Mr Justice Jacobs' case, where it was a case of joinder before trial, if the case had gone ahead and if he decided, or the trial judge had decided that there was no jurisdictional problem, then there could well have been a money judgment.
Yes.
Whereas you say you're not seeking that, and though no doubt the precise formulation of your declaration might be argued about, it's broadly as per your 10.3 paragraph.
Yes, yes, and we greatly...
Those are potentially different things, because the money judgment is final, whereas the declaration leaves some things to be sorted out in Lebanon.
Yes, we're careful not to trespass on the toes. I mean, it's sort of dangerous for counsel to leap on suggestions from the bench, but we do so, and I gratefully adopt that point. So that leaves gateways. I've dealt with real issue on the first limb of Gateway 1. My learned friend takes an additional point in relation to Gateway 3 on the substantive basis. He says he takes a proper party point on the substantive basis, which he doesn't take on the enforcement basis. And he says that the proper party limb, the second limb, isn't satisfied because the substantive basis claim goes beyond the ambit of the claim against Mr Safa. He addressed called on this earlier. And in our submission, the well-known test as to the degree of connection that's required is that identified by Lord Collins in Altimo, whether the claims involve one investigation or are closely bound up, or there's a sufficient connection or common thread between them. So there needs to be a sufficient connection. There doesn't need to be complete overlap. The claims don't need to be identical. And here in our submission, there could hardly be a closer connection. As the judge held, the issue of Mr Safa's liability to Mozambique is a fundamental and integral part of the claim, against the substantive claim against Mrs Safa. It's the essential predicate. It's the first step. You don't get there until that's been done. And so the mere fact that the claim against Mrs Safa involves one additional issue, whether she's succeeded to liability in respect of that very claim, doesn't mean that there's not a sufficiently close connection. Both are seeking to establish liability for precisely the same wrongdoing.
And as I've understood you, the issue which you're asking the English court to decide, because it's common ground that she is the sole heir,
Yes.
is whether a judgment which is essentially one in tort, where the amount has not been crystallised, counts as an obligation or debt for the purposes of the Lebanese rules of succession.
Yes.
Is that right?
That is right. There's one additional point, which is they say that a liability in tort arising out of criminal conduct also doesn't pass. It's a very similar analysis.
And no more than that?
No more than that. Oh, again, at this stage, we don't have a responsive pleading. It may be that they think of other points. But as things stand,
So those are the points which have been identified.
those are the only 2 points that have been identified.
That you were asking the English court to decide.
Yes.
And going back to the first point that you addressed, which is the dicey rule and all
Yes.
of those points, and also the Viegas points.
Yes.
Characterization depends on identifying the issue. That's what the authorities show. So one needs to know logically what exactly the issues are before you can do the characterization. And so, as I understand your submission, you're saying that at this stage you have a serious issue to be tried case on this, i.e. that the rule doesn't prevent you. But the exact application of the rules about administration of estates as opposed to succession may turn on the issues which will only be fully identified hereafter.
Yes, we accept that.
Sorry, I'm furiously writing a note. I should have asked you this at the outset. Is there a transcript being
I believe there is.
produced?
Yes.
That
We'll
would
make
be
sure
very
everyone has
helpful
copies.
if we could be provided with it. Thank you.
So that's gateway 3. Other gateways. So the judge also found that one or more of the other gateways on which Mozambique relied to obtain permission to serve out against Mr Safa apply. And my learned friend's only challenge to that decision is to say, well, the claim against Mrs Safa isn't the same as the claim against Mr Safa. They say the claim against her is based solely on her responsibility for Mr Safa's liability under Lebanese law relating to the administration of estates, and it doesn't have any factual or legal link with England and Wales. And in our respectful submission, that mischaracterises the claim against her. Whether there's liability on the part of Mr Safa that is capable of being succeeded to by Mrs Safa is the only issue on the enforcement basis claim, and as I've said, it's an integral and fundamental part of the substantive basis claim. The fact that she's become liable by operation of Lebanese law doesn't change the fact that the claim is for relief in respect of Mr Safa's wrongdoing. That the nexus between the claim and the jurisdiction is the same, and the same gateways in our submission should apply. If you take an example of a foreign company that enters into a contract with a claimant governed by English law, the foreign company is sued in England and permission to serve out is obtained, and then it undergoes some form of reconstruction, foreign law reorganisation process, or a merger or a corporate succession, so that there might be an issue about whether the successor has acquired the foreign company's obligations. If the claimant then seeks to add or substitute the successor entity, the claim wouldn't cease to be a claim in contract just because the succession took place under the laws of utopia. It would remain a claim in contract.
Some of the gateways don't seem that you're relying on, don't seem to refer to the conduct of anybody in particular. So the most obvious one is tort, I think. Where it's framed by reference to where the damage occurs, and then where acts took place, and then which is the governing law. But the first is where the damage was sustained.
Yeah.
But on the other hand, but it does then say it's a claim made in tort. Now, is it fair to describe your claim against the appellant here as a claim made in tort?
Well, if we took the enforcement basis first, it's a claim for a declaration as to Mr Safa's liability in tort to the Republic. So we'd say there, answer yes. I can see the complication on the substantive basis claim, but in our submission, it's the same claim. We're just bringing it against the person who's liable for it at the end has changed mid proceedings. I mean, if we just take a claim in respect of a contract, for example, if the claim that Mr Safa is liable is a claim in respect of a contract, why, I ask rhetorically, would a claim that Mrs Safa is liable for that same conduct not also be a claim in respect of a contract?
Was jurisdiction founded against Mr Safa on the basis of claim in respect of a
Lord,
contract, or was that against the companies?
Well, I'm afraid I'm in difficulties on that. It was before my time, and I just don't know.
Yes. It's not obvious that he would be party to any contract.
He certainly wouldn't be party to a contract. No. I was involved in the trial, so I'm sufficiently aware of the facts to be able to deal with that. No, it wouldn't be suggested that he personally was a party to a contract. But in our submission, that's not necessarily fatal to a claim being in respect of a contract. Yes. It doesn't have to be against a party to the contract.
Yes. Well, we're rather in the dark as to the basis on which jurisdiction was founded in respect of these other gateways.
I appreciate that, my lord, and I'm afraid I can't take it any further.
Okay.
That leaves us with forum, which arises only on the substantive basis. We've addressed this in section E2 of our skeleton. I'm not going to repeat what we've already said, but I will just highlight a few short points. The first and obvious point is that it's well established that a decision on forum is an evaluative decision with which this court should be slow to interfere, and this judge was particularly well placed to make it, having case managed the claims in respect of Mr Safa's wrongdoing for many years. Second, we've summarised in paragraph 81 of our skeleton the various matters that the judge took into account, and my learned friends haven't identified any error of principle in his approach. They just say effectively that he should have weighed things differently. And third, and this is the point that the court debated with my learned friend Mr Holden earlier, my learned friend's submissions on forum address only the additional issues that arise on the substantive basis. But if one's considering the substantive basis claim properly and as a whole, establishing that Mr Safa was liable to the Republic for his wrongdoing is an essential first step. And that's simply ignored in their forum analysis. They haven't conceded that they should be joined on the enforcement basis, and they haven't conceded the issue of Mr Safa's liability to Mozambique. They can't have it both ways. And then if one is addressing the forum question on the footing that Mrs Safa, that they're wrong on the enforcement basis, then she's already joined and a party to proceedings here anyway, and that's relevant when considering whether this is the appropriate forum to complete the exercise and resolve whether she's succeeded to his liability for that same wrongdoing as a matter of Lebanese law. Fourth, the judge said, and Mr Holden took you to this earlier, that this is paragraph 61 of his judgment, the claim is enabling the English court to complete its work in light of Mr Safa's death in the course of the proceedings. And he said it would be unsuitable and unjust for the court to leave matters open and unfinished. And we respectfully adopt that. When one properly characterises the claim as one to render the proper person liable for the wrongdoing that this court's been seized with for 7 years, in our submission this is the appropriate forum. The task that the court embarked upon was to address whether Mr Safa had committed wrongs against the Republic, and if so, to determine liability for that wrongdoing and grant a remedy against the person liable for it. And that's the position that we'll be in if Mrs Safa is joined on the substantive basis and we succeed. We'll have established the wrongdoing and the person's liable under English law and under the law of his domicile. We're not seeking to steal a march on enforcement in Lebanon, but to complete the original task, to put us in the same position as if we had a judgment against Mr Safa on the day after he died. Any resulting judgment on liability will still have to be enforced in Lebanon. And my learned friends, in a skeleton, we didn't hear anything about this earlier, but in a skeleton, they say that Lebanon is the appropriate forum. But their only basis for that, their only point for that, in fact, was that the substantive basis claim involves some Lebanese law issues. But one, that's a factor that the judge expressly took into account. And as he said in paragraph 59 of the judgment, it's not clear what those issues are, and much of the Lebanese law seems pretty clear anyway. One of the issues that they originally relied upon, the disclaimer issue, that's fallen away entirely. And that leaves two issues. Those are the ones that I've been discussing with my Lord Justice Miles. Whether liabilities for wrongdoing that hadn't been quantified pass, and whether tortious liability arising from criminal conduct pass. And we've got expert evidence on those already. And the English court's perfectly capable of deciding them, as it does questions of foreign law day in, day out. And otherwise, apart from that one point, their own evidence is that Mrs Safa's closest connections are not with Lebanon, but with the UAE. She owns interests in a portfolio of properties in Belgravia, so she's got connections here. There's obviously a Cambridgeshire factor. There's substantial accumulated experience of solicitors in counsel for Mozambique, for Mr Safa's estate, and Mrs Safa herself. And so in our submission, the judge's conclusion in the round that this court is best placed to determine not only the question of Mr Safa's liability as between Mozambique and Mrs Safa, but also whether that's now become the liability of Mrs Safa under Lebanese law, rather than that being determined in two phases in two different places, is one that he was more than entitled to make. My lords, unless I can be of any further assistance, those are our submissions.
Thank you very much. Yes, Mr. Howe.
I apologise before I hadn't sat down. Before I nearly hadn't sat down. We have copies of the judge's directions email, if I could hand those up.
Oh, thank you very much, yes.
My lords, my lady, I have some brief points in reply. Obviously, I will not repeat things I've said before, at least not intentionally. The first point to note is my learned friend raised what appears to be an entirely new argument based on CPR .12 sub-rule 5 to the effect that the technical result of the estate not having an appointed representative for the purposes of proceedings at the moment the judgment was handed down means that the estate is not formally bound by the judgment. Now, there are a number of observations to make about this argument. The first is that it is on the face of it somewhat improbable that the estate is completely unaffected by the handing down of a judgment which contains numerous findings in relation to Mr Safa, including findings in relation to numerous legal arguments that were made on his behalf during the course of trial, and which on the face of it present issue estoppels, which could not then be contested by the estate subsequently, whether or not they had an appointed representative at the time. The second point to note is that it appears to be the opposite of what my learned friend was saying, at least until today, in relation to the position regarding the representation of the estate in relation to the judgment. You'll find in the Respondents' skeleton at paragraph 33.1, where my learned friends are addressing the question of the status of the judgment, the following. It's at page 60, tab 3.2 of the core bundle. Or internally, it's page 9 to 10 of the skeleton if you have it separately. And they're addressing the question of whether or not the claims against Mr Safa have already been tried and determined at paragraph 33. 33.1, it said, that is wrong. The 2024 judgment expressly records at 34 that it did not determine the Safa claims, which therefore remain live between the Republic and Mr Safa's English estate, in relation to which a Mr Akram Azuri has been appointed a CPR 19.121b representative. So if the point was to be made that because of a technical gap in the appointment, the status of the judgment was somehow in doubt, that would have been the moment to make it, but it was not made. However, even assuming that it is technically right that the judgment is not binding on the estate because of that technical gap in the appointment of a representative, it is still the case that the Republic wishes to have its cake and eat it, which is to say to this court, oh, well, there's still a real issue between us and the estate because formally there's this little gap here, this lacuna, as a result of the rules. But nonetheless, in response to questions both from us in correspondence and from the court, the estate, the Republic, has not come out and said, we agree that there is no issue of stopper effect from the judgment. And that is the critical question. And in response to questions from this court, well, in response to questions from us via the solicitors, our solicitors, we had no response at all. We received a dead bat. In response to questions from the court, you were treated to, frankly, evasive answers along the lines of, well, Mrs. Safa wouldn't be bound by the judgment. She would be entitled to make submissions, and what we would say would depend on what she submitted and case management by the court. It is an extended exercise in cakeism. The position must be either that there is genuinely a substantive issue to be resolved between the Republic and the estate, a real issue, which is reasonable for the court to try, in which case, as a matter of substance, that must be something in relation to which Mrs. Safa would actually have a genuine opportunity to open up and challenge without being bound by any of the prior findings made in the main judgment, or the prior findings constitute an issue estoppel between the estate and the Republic, which appears to be the irrefutable position on the basis of the well-established principles, in which case the suggestion that there is a real issue is a fiction. But in my
May I just see whether the suggestion of cakeism might be reversed and see what you say to this. Do you say that the effect of the judgment is to, or would be, to create issue estoppels if your client was bound? Was made a party, I'm so sorry. Well, I'll say that again. So, do you say that there would be issue estoppels if your client was made a party and served validly out of jurisdiction?
Well, my lord, on the first point to notice, it's not for me to say whether there's an issue estoppel as between the Republic and the estate, but on well-established principles.
Not between the Republic and your client.
That's a different matter, my lord.
That's the question I'm asking.
The reason why it's relevant for the gateway, this issue is relevant for the gateway, is because one needs to determine whether there's a real issue between the Republic and the estate. That's the starting point. Unless there is a real issue, the gateway can't apply. That's why I'm addressing the position of the findings between the Republic and the estate. It must, however, whether my client, if joined, would have any real opportunity to challenge those matters would in turn depend on whether there was an issue estoppel. On the face of it, there has been a 3-month trial. The judge has handed down a lengthy reserved judgment, and the result of those findings, as against Mr Safa, must presumably be that they're binding on the estate, unless, as my learned friend has suggested today, there's some technical reason why the handing down of the judgment effectively nullifies the trial. That argument appears to be highly improbable, to put it at its lowest. It would upset many concepts of finality and litigation if it were the case that following a judgment handed down in which a deceased had been involved, that his estate was not bound by the findings in the judgment merely because at the time of the handing down he happened to have no personal representative appointed or no representative appointed for the purpose of the proceedings. So in those circumstances, it appears to us to be almost irrefutable that the judgment gives rise to issue estoppel as between the estate and the Republic, and there's no practical method by which Mrs Safa could challenge that. However, if in answer to our correspondence the Republic had said, or indeed if my friend had said to this court, clearly, we entirely accept that the judgment is a thing writ in water as regards Mr Safa, all bets are off. We're not going to rely on any of the findings against Mr Safa as constituting any form of finality or estoppel, then I agree, the argument would be different. But the Republic has had many opportunities to say that if it was really its position. It's not at all surprising it isn't its position, quite understandable, but the net result is the idea that there's any real issue that remains to be tried between the Republic and the state is, as I say, essentially a fiction. It's an argument constructed on technicalities that bears no relation to reality. And of course, it is important to note that the rule expressly requires not merely that there be an issue, but there be a real issue, not some fictional or imagined issue. There has to be something of substance.
Well, that's been interpreted to mean something that gets over the summary judgment.
Quite so. And the other way of looking at that would be, if it is the case that the Republic would be entitled, on the basis of the findings in the judgment, to enter a judgment similar to or identical to the Prininvest judgment, there is no real issue. And in my submission, that's plainly the position.
Can I just ask this? Sorry, it's not directly the point you were making, but it's related to it. What would have been the position if the judge had determined the application for joinder before handing down the judgment? Because the application was made before, and the judge seems to have decided as a case management matter to put off the application and give judgment, and he made various reservations and so on. Would this argument be available to you if this application had been heard before judgment?
The argument would not have been available to me if the joinder had taken place before judgment and the position was that the new parties, the heirs, were given a fair opportunity to put in further evidence, call further witnesses if they wanted to, and address the matters that had been raised at trial before any findings were made. Because if that were a genuine opportunity, it could then be said that there was still a real issue in which the heirs could be engaged. In those circumstances, the situation would be similar to PIF's. Another way of thinking of it would be, for example, what if the PIF's application to join had taken place partway through the trial or near the end of that lengthy trial? In those circumstances, would there still have been a real issue between the claimant in that case and the defendant, which was reasonable for the court to try, to which the answer is yes, it's still ongoing and hasn't been determined. But in the present case, the application to join is simply too late. The issue had disappeared.
And did your clients ask for an opportunity to do that before the judgment was given?
Well, my lord, I'm afraid I don't know the answer to that question, but they were involved at any rate, as it appears, very late on, shortly before the judgment was due to be handed down. As you can see, there's some correspondence mentioned in the order made in June, shortly before the hand down of judgment received from my instructing solicitors. I'm afraid I don't know what the correspondence was about. I simply wasn't involved at that stage. But in any event, that would have been extremely late to be given any opportunity. I should also add that I am instructed that the claimants were well aware of Mr Safa's very serious state of health throughout the proceedings, and certainly by the time of trial. So if they had wished to take action earlier, they had plenty of opportunity to do so.
Yeah, there was quite a gap between his death and the circulation of the draft judgment.
Yes, that's right. The
Several
judgment.
months.
The judgment is the end of Mr Safa sadly died in January 2024. The judgment was handed down at the end of July, 28th or 29th, and the order was in June 24th or thereabouts. The order regarding the hold the line order, if I can call it that.
Yeah.
Yes.
It was 28th of June. So that was very late on before the judgment was handed down. So on the question of a real issue, in my submission, the arguments based on, technical arguments based on the estate not being banned are neither here nor there. They're simply ill-founded. Secondly, my learned friend referred to HC trading, which is in the authorities bundle at tab 15. And this is a decision of Deputy Stephen Houseman, QC, on the question considered by this court in Ersty, which is the question of what is a real issue which is reasonable for the court to try. I only have two short points to make about this decision. If one looks at the passage in the judgment of the deputy at paragraph 15, which is page 417, tab 15, page 417, the deputy sets out a series of principles in relation to what is the concept of what is a real issue for which is a reason for the court to try, and in that context refers to the CA in Red October, which is Ersty. However, it's not clear because he doesn't provide references to the extent to which he appears to apply a looser test or suggest a looser test than Red October, where he has derived his looser test from. So my first point is in my submission, the definitive statement of what is a real issue is to be found in the Court of Appeal in Red October and not in this first instance decision. The second point is, of course, that to the extent it is a decision, it's simply a decision on the facts, applying the question of real issue to the particular facts of that case. That brings me to my third point in reply, which is my learned friend's submission about Ersty, Red October. That's in tab 8 of the bundle, starts at page 189. And my learned friend said in relation to this that this decision was concerned only with the question of whether there was a real issue which was reasonable for the court to try, and not the question of whether there was a real issue. Now, that is, in fact, simply incorrect if one looks at paragraph 78, which is the paragraph that I referred the court to earlier. This is on page 221. And perhaps it's easier to start on page, just the previous page, 220, at the very bottom of the page. They say, even if the judge had been correct to conclude the start of 77, that the bank had not technically submitted to the Russian court, the question was not whether the bank was entitled to bring its debt and contractual claims or conspiracy claims, but rather whether in all the circumstances, in the language of the Gateway, such claims gave rise, as between the bank and D1, D2, to a real issue which it's reasonable for the court to try. This is a question which the judge did not address. In our judgment, even if contrary to our view, there had not technically been a submission to the Russian court, in all the circumstances, it could not be said that the tests of real issue and reasonable for the court to try have been satisfied. So the court then separates those two limbs. And addressing the first limb, they start at paragraph 78.1. This is where they address real issue. And they then make the statement that I referred to earlier, which is there was no real issue as the claims had been admitted. And again, subparagraph 2, consequently, as at the date the bank was entitled to obtain or apply for judgment against both D1 and D2. So that's the issue, question of whether there's a real issue. and that's the basis on which the court concluded there was no real issue, and that is the one that we say is essentially indistinguishable from the present case. There's no real issue. It's at the bottom of the page. The court then turns to the question of whether it was an issue which was reasonable for the court to try, paragraph 4. In such circumstances as at the date of the application, there was no real issue between the bank, and certainly none which was reasonable for the court to try. So they then go on to consider the second part of that phrase, which is the reasonable to the court to try. So my own friend is incorrect to suggest that the Court of Appeal was not there considering and expanding the test for what is a real issue, because that is exactly what it was doing. Fourthly, my own friend referred briefly to the Hotel Portofino case, which is the additional authority that the court drew our attention to this morning. And he suggested that in relation to that case, referring to paragraph 25 of the judgment of Mr Justice Foxton, as he then was, that this case was forward-looking because there were still issues to be resolved. Now, of course, that is circular. It's based on his proposition that there are still real issues to be resolved. But if there are no real issues to be resolved, then this is what Mr Justice Foxton would describe as a backward-looking case. And the problems of the backward-looking case, which is bringing a party in when they've had no opportunity to contest the case, is inherently unfair and contrary to natural justice. Turning to the fifth point. The fifth point was my own friend made some submissions concerning the Lebanese principle of no inheritance before payment of debts. Now, in my earlier submissions, I summarized the position broadly as follows, that there is a principle of no inheritance before payment of debts. But secondly, of course, under Lebanese law, as under most civil systems of law, there's immediate inheritance of the corpus of the deceased's affairs because they have no concept of an estate. The deceased ceases to exist, so his corpus then devolves immediately by operation of law onto the designated heirs, subject to disclaimer and so on and so forth. In addition, under Lebanese law, there are certain circumstances in which the heir is able to deal with the debts, with the assets, but may find himself subject to liabilities to creditors, because creditors also need to be paid out of the proceeds of the assets. The problem with my own friend's submission, which is to the effect that, well, there's no administration under Lebanese law because, in fact, there's an immediate succession of the assets and /or liabilities to the heirs, and they are then entitled to deal with them as they will, is it ignores the basic principle that characterization is not a matter for Lebanese law, but English law. It doesn't matter how the foreign law describes the process. Characterization of what falls into the box of administration and what falls into the box of succession is a matter for the English court. And the line between characterization and succession has, as I say, been very clearly drawn in Viegas. I'll come back to that point in a moment or two, because my own friend also made some submissions about that case. Secondly, of course, the expert evidence goes a number of different ways in relation to how the concept of no inheritance before payment of debts is dealt with under Lebanese law, to the extent that it's relevant, which it probably isn't, given the correct approach to characterization. For example, Professor Slim, in the supplemental bundle at paragraph 53, this is tab 6, page 89. Just after he has, at the top of the page, he's talking about the concept of no inheritance until after settlement of debts. He says this could suggest they prescribe the transfer of assets left by a deceased at his or her death before payment of his or her debts. However, such a reading understanding is not correct for at least 3 reasons. And he goes on to address that Article 13 doesn't address the issue of the time on which the assets, rights, etc. vest. Second, the law dated 23rd of June 59, and the laws applicable to Lebanese Muslims, does not organise a mandatory procedure for the administration of taka, the mass of what's left. That's sometimes called the corpus. It's also the Muslim expression appears to be taka. And then third, under Sharia rules, the maxim no inheritance and lawful settlement of debts is not interpreted as prescribing transfer of assets left by a deceased person before the payment of his or her debts. And he explains, according to Sharia rules, derived from teaching of the Islamic Hanafi school, the distinction is to be made between a situation where the taka, the mass, is fully insolvent, entirely absorbed by debts, and the situation where the taka is economically solvent, not absorbed by debts. In the first case, the assets left to the deceased are not transferred to the heirs. In the second case, they are immediately transferred to the heirs. Now, why does that matter? It matters because it shows that the way to determine whether something is to be regarded as an administration matter or a succession matter cannot be resolved by looking at the courts and shouldn't be the foreign rules and shouldn't be anyway. It's resolved by looking at how the English court characterises the matter in question. Next, my own friend referred in order to the Degazon case, which is in the authorities at tab 3, and he made a number of submissions about this. First of all, he referred to page 38. And it's important to note that the passage he drew attention to contains a pithy and authoritative statement of the relevant exclusionary rule of jurisdiction in relation to administration. It's in the quoted passage on page 38, where it said, "It would appear the primary reason for the rule," this is a few lines down, "is the one cited by Mr Justice Laycraft, namely that all questions relating to the administration of the estate ought to be determined by the forum which authorised the personal representative to act. The settlement of liabilities, as distinct from the distribution of assets, is a fundamental part of the administration of an estate." And that, of course, is essentially the same as what is subsequently said by this court in the Viegas case. What it means is one doesn't look at the sequence of events. It doesn't matter whether under the law of Lebanon or the law of France there is a particular procedure for how one handles the assets and liabilities of the state. What one looks at is whether the matter in question relates to administration. And if the matter in question is to do with the settlement of liabilities, and indeed the determination of liabilities, as opposed to the distribution of assets following determination or even at the same time, it is a matter of administration. That's the principle on which it's founded. And my own friend spent quite a lot of time concentrating on timing and suggesting that because there's immediate devolution, there can be no administration. That is simply contrary to the basic fundamental approach to characterization of the issues under English law. Except in the simplest possible estate, there will always be administration, even if it's simply counting up the number of pound coins or equivalent that someone had in their wallet and working out whether they owe anything. That process of establishing the state of the account, the assets and liabilities, is part of the administration. It's completely irrelevant whether in the meantime, under the particular local law, the heir is entitled to or is not entitled to deal with the assets as his own. At some point or another, as part of the administration, it will be necessary to determine whether a debt attaches to an estate or a liability does. In the present case, what the respondent wants to do, the Republic wants to do, is to seek to have this court determine that its alleged debt owed by the Mr Safa attaches to his corpus, or the corpus of his affairs, in Lebanon. That is part of the process of administration.
There isn't any process of attachment or whatever. I mean, the evidence demonstrates that the heirs become liable. There's clearly possible questions about the extent of the personal liability of the heirs. But some of these statements have to be read in context. They're clearly talking about some sort of process of administration, I'd suggest.
Well, I
And
understand.
when it talks about the settlement of debts and so on, that's by the administrator. That's
Yes.
the reason for the rule that it's territorial, etc. But there isn't. It's dangerous to use phrases like whether the sums attached to the claims attached to the estate, because there isn't an estate here.
I use the expression corpus.
But it doesn't attach to the corpus either, because it doesn't, as it were, it's not, as it were, a claim to the assets, as I understand it. It's a claim against the individual heirs, but there are limits on the extent of their liability.
Yes, but in concept, it arises only because it formed part of the corpus of affairs of the deceased person, the liability. And my lord, I do stand corrected. You're right, I shouldn't use the word procedure. I should say the matter. One has to identify what the matter is. If the matter is to do with the identification of what liabilities the estate has, it's a matter of administration and not succession. So the word procedure can be a little bit misleading in these circumstances because, of course, my lord, you're quite right. There may be no formal procedure in some jurisdictions. It looks like in Lebanon sometimes there is and sometimes there isn't, depending on the circumstances. But there's no necessary requirement for it, as one can see from the expert evidence. The second point in relation to Degazon is that my learned friend suggested that the principle under Rule 160, DICE, only applies where you have a formal appointment of an administrator or of another representative of the estate, and it's that person who's clothed with the as it were, immunity from being sued under English law. That also is incorrect, as is clear from the case, firstly from the general principle, but also of characterization, which is one looks to the substance of the matter and not to the particular way in which it's treated under foreign law, but it's also clear from the Akulopoulos case that in fact precisely identifies that issue, because in that case, if you turn to that authority, it's tab 1, at page 13, in the highlighted passage, the judge is citing the evidence of Greek law, which is, like all civil law systems, very similar to Lebanese law in this regard. The evidence with regard to Greek law is this, that under the law of that country, there's no system at all by which someone is granted a formal position corresponding with executor or administrator in this country. On the contrary, those persons who are the heirs are fixed by law with the rights and duties corresponding with the rights and duties of the executor or administrator under English law, including the duty of paying the debts. So that's the approach that the English court takes to deciding whether someone is acting in the capacity as an administrator for the purposes of the rule. Formal appointment is not necessary for the rule to apply. Indeed, it would be very odd if it were otherwise, because given this appears from the cases one can see reported to be the general position under civil law, it would follow that civil law countries were particularly disadvantaged when it came to the application of the DICE rule in 160.
It might be said that that case had nothing to do with the DICE rule. I think that was the submission.
It may have had nothing to do with the DICE rule, but it does explain the status of persons who are appointed or treated as being appointed as administrators for these purposes.
Now, how much more do you have to say?
I only have a couple more points, my lord, then I'm done.
All right, good.
Next, in relation to Viegas, my learned friend suggested that Viegas was not to do with DICE Rule 160. That is to misunderstand the reasons we rely on Viegas. We rely on Viegas for two important principles, both of which I showed you in submissions. The first is that Viegas contains a very useful statement of the concept of characterization and explains that characterization is a matter for the English court. And the second is that Viegas also contains a definitive and authoritative statement as to how one divides matters between administration and succession. And I showed you those passages first time round, so I won't go back to them. finally, my lords, in relation to the gateways, my learned friend made the submission that the gateways on which the respondent could rely in relation to the claim against Mrs. Safa are the same gateways as it could rely on in relation to the late Mr. Safa and the estate, because it is the same claim. Well, my lords, it's a short point. One only has to read the joinder particulars of claim to see that it is not the same claim. There are no allegations of any contractual misfeasance, tortious activity, unjust enrichment, or anything else as against Mrs. Safa. The only claim against the heirs in the joinder of particulars of claim is a claim founded on the principles of Lebanese law, which is said to give rise to their liability. It is therefore simply wrong to suggest that it's the same claim. It's a completely different one, founded on a distinct set of principles. Part of the groundwork for the claim is to establish the liability of Mr. Safa, but that is not the claim that's being advanced against the heirs. That is a conflation of two completely different things. I was just checking that my learned junior didn't have any points on forum. Those are my submissions, and he has no further reply.
Thank you very much. Right, well, we will reserve our judgments. At this stage of the term, I won't make any promises as to when they will be available to you. When they are, a draft will be sent to those whose names have been provided. That will be subject to the terms of the embargo, which you're familiar with and which you know the court takes very seriously. It will be for the purpose of correcting any typographical errors or minor factual errors or matters of that nature, not for the purpose of re-arguing anything. We will live in the hope and expectation that in the light of whatever we decide, you will be able to agree an order for us to approve. If you find that you can't, then we will have short written submissions and we'll deal with consequential matters without a further hearing. I think that's all I need to say, other than to thank you all for the interesting submissions that we've heard, both those who have spoken and those who have supported. And for those like us who live by terms, to wish you all a good vacation.
All rise if able.